Supreme Court of India in the matter of ADITYA KHAITAN versus State of Jharkhand allowed the appeal and held that we are of the opinion that High Court erred in not invoking power under Section 482 CRPC in present case. The High Court, having failed to invoke its power under Section 482 in the appeal, we invoke the same and quash the FIR on which no further proceedings will be taken. The complaint alleged that first accused company expressed its intention to enter into contract to carry out a portion of project for which contract was entered into with NBCCL. There was a contract entered into between first respondent, accused, and complainant based on which work was also commenced. Allegations laid down in FIR mostly constitute narration of bills submitted by complainant and the part payments made by accused as also the balance remaining. It was then submitted that for reason of non-completion of work within stipulated time, as agreed with NBCCL, the work was directed to be stopped by NBCCL. A proceeding was initiated by first accused before High Court against NBCCL in which complainant sought intervention which was denied by High Court finding there is no back-to-back contract for reason of restrictive covenant in the contract of the first accused with NBCCL. Complainant submitted that only then they realized there was stipulation in contract that subletting will be permissible only on consent of the principal. It was also stated in the complaint that later on directions of the High Court contract was resumed when even the complainant resumed their work as per contract entered into with first accused. This was after restrictive covenant came to the knowledge of complainant. Again, bills were submitted and part payments were made, wherein also there are amounts remaining due to the complainant. An application filed before NCLT by a complainant was rejected. Complainant had now invoked arbitration clause, but there was stay of arbitration as admitted by both parties due to moratorium issued by the NCLT. A reading of the complaint would indicate a contract having been entered into pursuant to which there were financial transactions and allegedly amounts were due to complainant. Supreme Court said we would assume for the moment that restrictive covenant not available in the contract with NBCCL was not disclosed by first accused when they entered into contract with complainant. Reading of complaint would clearly indicate that the complainant was aware of the fact at inception itself that they were entering into contract to do portion of the work as per contract awarded by NBCCL to accused company. While complainant alleges suppression, obviously, complainant also did not make any effort to look into contract entered into with the NBCCL by first accused. In any event, Supreme Court said, even if we assume that the subcontract was without a consent from principal and restrictive covenant was suppressed from them, it will only entail an action by NBCCL as against first accused company. NBCCL cannot take any action against complainant since it has no privity of contract with the complainant. Court said that even if there is restrictive covenant and contract of NBCCL was terminated for reason of sublease, that alone cannot absolve first accused company from satisfying bills raised by complainant if it is in accordance with contract they entered into. Complainant had taken steps for recovery of amounts due which unfortunately had been stalled by reason of moratorium by NCLT. Complainant would have to take proper recourse and avail the recourse and legal remedies for recovery of money, which is crux and essence of allegations as court discerned from the complaint, read in its entirety. Court said that we do not find any criminality arising from the allegations and prima facie allegations do not constitute any offense or make out any case against the accused persons.